trace the growth and development of administrative law in the United States of America, USA. Administrative law in the United States of America has developed as a result of the increasing functions of the government and the need to regulate administrative agencies. Unlike England, where the rule of law initially delayed the growth of administrative law, the United States recognized the necessity of administrative agencies much earlier because of rapid industrialization, economic regulation, and social welfare programs. Today, administrative law occupies a central position in the American legal system. It regulates the powers, procedures, and functioning of administrative agencies while ensuring that their actions remain subject to judicial review and constitutional limitations. Legal provision. The development of administrative law in the USA is based upon the Constitution of the United States, the Doctrine of Separation of Power, the Administrative Procedure Act 1946 APA, judicial review by federal courts, federal statutes establishing administrative agencies and independent regulatory commissions. Essential features or contents. The growth and development of administrative law in the USA may be understood under the following heads: constitutional background, doctrine of separation of power, rise of administrative agencies, New Deal era and administrative expansion, Independent Regulatory Commission, Administrative Procedure Act 1946, Judicial Review of Administrative Action, present position in the USA. Explanation. Constitutional background. The Constitution of the United States established a democratic government based on the principles of constitutional supremacy and limited government. It divided governmental powers among the legislature, executive, and judiciary while ensuring that each organ functioned within its constitutional limits. Initially, the federal government performed limited functions. However, with economic growth, industrial development, and increasing governmental responsibilities, the need arose for specialized administrative bodies capable of regulating complex public affairs. This constitutional framework provided the foundation for the growth of administrative law. Doctrine of separation of power. One of the distinguishing features of American Constitution is the doctrine of separation of powers. Legislative powers are vested in Congress, executive powers in the president, and judicial powers in the courts. Although this doctrine requires separation among the three organs, modern administrative agencies exercise a combination of legislative, executive, and quasi judicial functions. They make regulations, implement laws, and decide disputes. Initially, this concentration of powers was viewed with suspicion. However, American courts recognized that such agencies were essential for efficient administration provided that adequate safeguards and judicial control existed. Rise of administrative agencies. The rapid industrial growth of the 19th century created new economic and social problems that required government regulation to deal with matters such as transportation, banking, labor relations, securities, communications, public health, and environmental protection. Numerous administrative agencies were established. These agencies were entrusted with specialized functions requiring technical knowledge and expertise. Their growth marked the beginning of modern administrative law in the United States. New Deal era and administrative expansion. The greatest expansion of administrative law occurred during the New Deal era under President Franklin D. Roosevelt in the 1930s. The Great Depression created severe economic and social challenges that required extensive governmental intervention. The federal government established several administrative agencies to regulate industries, stabilize financial markets, protect workers, promote employment, and implement social welfare programs. This period witnessed a significant increase in delegated powers and administrative regulation, making administrative law an indispensable part of American governance. Independent regulatory commissions, an important feature of the American administrative system, is the establishment of independent regulatory commissions. These bodies are created by Congress to regulate specific sectors of the economy and public administration. For example, Federal Trade Commission (FTC), Federal Communications Commission (FCC), Securities and Exchange Commission (SEC), and National Labor Relations Board (NLRB). These commissions function independently of direct executive control and perform legislative, executive, and adjudicatory functions. Administrative law regulates their powers, procedures, and accountability. Administrative Procedure Act 1946. The enactment of the Administrative Procedure Act 1946 APA is considered the most significant milestone in the development of administrative law in the USA. The act established uniform procedures governing the functioning of federal administrative agencies. It lays down rules relating to rulemaking, administrative adjudication, public participation, administrative hearings, publication of regulations, and judicial review of administrative decisions. The APA promotes transparency, fairness, consistency, and accountability in administrative governance and is often regarded as the constitution of administrative law in the United States. Judicial review of administrative action. Judicial review is one of the most important safeguards in American administrative law. Federal courts have the authority to examine the legality of administrative actions and ensure that agencies act within the powers conferred upon them. Courts may invalidate administrative actions that are ultra vires, arbitrary, or unreasonable, contrary to statutory provisions, in violation of constitutional rights, or contrary to principles of the procedural fairness. Judicial review ensures that administrative agencies remain accountable and operate within the framework of the Constitution and federal laws. Present position in the USA. Today, administrative law is one of the most developed branch of American public law. Administrative agencies regulate almost every important area of the public life, including environmental protection, consumer protection, banking and finance, telecommunications, labor relations, healthcare, taxation, and national security. Modern administrative law seeks to maintain a balance between efficient administration and the protection of constitutional rights through judicial review, procedural safeguards, and statutory regulation. The American legal system ensures that administrative agencies remain accountable, transparent, and responsive to the rule of law. Case law. Chevron U.S.A. Inc. versus Natural Resources Defense Council 1984. The U.S. Supreme Court held that courts should generally defer to reasonable interpretations adopted by administrative agencies. Where statutory language is ambiguous, the decision became the foundation of the Chevron Doctrine regarding judicial review of the administrative action. Humphrey's Executor versus United States 1935, the U.S. Supreme Court upheld the constitutional validity of independent regulatory commissions and recognized their independent status within the administrative framework. Importance or significance. The development of administrative law in the USA demonstrates the need for specialized administrative agencies in a modern welfare state. It provides an effective legal framework for regulating administrative action while safeguarding constitutional rights through judicial review and procedural fairness. The Administrative Procedure Act 1946 has further strengthened transparency, accountability, and uniformity in administrative governance. Conclusion. Administrative law in the United States has evolved from a limited administrative system into one of the most comprehensive systems in the world. The Constitution, the doctrine of separation of powers, the rise of administrative agencies, the New Deal reforms, independent regulatory commissions, the Administrative Procedure Act 1946, and judicial review have collectively contributed to its development. Today, administrative law is indispensable for ensuring efficient governance while protecting the rights and liberties of individuals.